May it please Your Honour, I am Struthers and I appear for the applicant. I have two submissions to make today, Your Honour, and I estimate that they will take about 4 minutes. Now, Your Honour, did you receive the PLSC ADV court visit questionnaire document that I filed with the court yesterday? Awesome. Does Your Honour have that in front of you? Cool. If you could just turn to page 3 of that document, Your Honour, you'll see two principal points there listed under B and C, and those will be my submissions today. May I proceed, Your Honour? Much obliged. Now, Your Honour, I observed the case of Vandenacre Construction Limited versus Wilson Mackay Trustee Company Limited between the 21st and 24th of February 2022. Now, Your Honour, this was in the District Court of Auckland before Judge Sharp. There were two principal issues here. The plaintiff was simply seeking payment of an unpaid invoice under a cost-plus construction contract. The defendant denied the claim was owing, claiming a set-off, and had a bunch of counterclaims, mainly for overcharging and some defective work claims, which seem to have fallen away after the beginning of the trial. Now, the primary facts were that the parties entered into a cost-plus contract for the remediation of some previous defective work and some renovations to the home. The plaintiff builder undertook these works, and the defendant paid some claims and invoices as they fell due. One of the principal issues between the parties was in June 2018. The defendants say they reached an agreement with the plaintiffs whereby they would go overseas and the plaintiffs would work for no more than 2 weeks while they're away, just finishing in some close-in works. Now, Your Honour, the defendants deny that this agreement was ever reached. They say they had to continue on the site to close in the works, and that there was no way that that would take 2 weeks. Now, when the defendants returned from holiday, Your Honour, they noticed that the roof was very shabby and they refused to pay the payment claim. Builder suspended works and cancelled the contract. Now, Your Honour, my first submission is something that surprised me, and that was the lack of technology in the courts. Having had a history in arbitrations, and seeing the use of a digital common bundle and a screen in the room where all witnesses, counsel and arbitrators alike can make use of that, can annotate on the screen. Experts can sort of point stuff out for everyone involved. Sort of makes it a whole lot easier, especially for construction cases where, you know, if you're looking at a defect on a roof, for instance, Your Honour, the judge is not going to know what the expert says when he says, you know, the cap flashing on the window on the bottom left corner. You know, it's quite difficult for the judge to see what that is. If you have a screen with the witness, you know, pointing to that defect, makes it a whole lot easier for everyone to understand. Do you want to have any questions? Much obliged. I'll now move to my second submission, Your Honour, and this is something I learnt. Now, I learned a lot about cross-examination, Your Honour, less about sort of how to do it and more about, it looks quite fun, seeing Mr. Stevenson in particular, who had been involved in this case for 4 or so years, and had a background with the witness, or the primary fact witness for the defendant, and seeing the way he used some of that prior knowledge to portray the witness to the judge in a way that he wanted to. Now, he knew from the judicial settlement conference that the witness was likely to lose her temper if she looked like she was starting to come across in the wrong way. Now, Mr. Stevenson played on that, and it seemed to work. Do you have any questions on that submission, Your Honour, on my submissions as a whole? Much obliged, Your Honour. That is the case for the plaintiff, the applicant, sorry.